we're a little bit later in the evening. I don't know if some of you maybe have young kids like I do. So I will go ahead and I'm going to share my screen with y'all, but I'm also going to show you the contact screen first so that if you do have any questions, if you have to take off a little early, if you have any questions, you're welcome to, at least take down my contact information so that, if you had a question about something that we talked about or something that you missed, I could send that to you. So let me just share my screen here with you. All right. So let's see. Let's get you to the last screen here. All right, so here is my contact information. So you can either reach me by phone or by email, melanie@hammelmanlaw.com. I'm also on Facebook, Twitter, Instagram. So if it's easier for you to, find me there and send me a message, that's totally fine. I just want everyone to know how to contact me in case you need something after the program is over. So now what we're going to do is play from the beginning. Okay, so just like Lorraine said, this is Estate Planning 101 or Essentials of Estate Planning. So what we're going to do here today is we're just going to talk about what an estate plan is. That's where we're going to start. So an estate plan, usually people think of a will whenever they think of estate planning. So it really is a collection of documents. So it's a few documents that sort of work together to express your wishes for your loved ones for either when you're incapacitated or when you've passed. This can be helpful for children, grandchildren, parents. You can also leave things to charities, pets, which seems, I get questions about the pets all the time. People think, I actually had a couple the other day say, I don't want to sound crazy, but I want to leave something to take care of my pets. I actually have it in my own. I'm not leaving $1 million to my pets, but you can at least leave money so that whomever takes your pets has the funds to take care of them. You can also provide for other friends and relatives. If you've got close friends, if you've got, nieces and nephews like I do that you maybe want to take care of, you can provide for any of those people. All right, the basics. So now we're going to start to sort of get into what the documents actually are. So, here. Who needs an estate plan? Everybody. Of course, that's my answer, right? Because this is what I do for a living. You don't necessarily need all the options. You don't necessarily need to have every single document or every single provision or, the most expensive estate plan, but it is good to at least have something down on paper. The reason is it can get pretty expensive pretty quickly if you don't have some indication as to what you want. And it also can sort of undercut if you have made some decisions for yourself. The course has no way to know what they are and absolutely no, reason to enforce them if you haven't put them in a legally enforceable document. It also can make things a little bit easier on your loved ones when you're gone. Unfortunately, sometimes death doesn't bring out the best in people. You get family members fighting who maybe wouldn't normally, or especially if you've already got some contentious relationships, that can sort of escalate things. Why should you make a plan? I just sort of went over some of these things, but it can help your children, grandchildren, other dependents. It can help you be able to determine what you want to happen. So you can either say, this is who I want to have, who I want my children's guardian to be. You can say, this is how I want my children to be raised. A lot of people don't know that you can include things like that. Do you want them to be raised in a certain religion? Do you want them to be, hot button issue right now, vaccinated or not vaccinated? There are all kinds of things that you can decide for your kids in your estate plan. You also get to decide what happens to your assets. You know, you've worked hard to make the money that you've made. You've worked hard to buy the house that you've bought. You know, if you have any business interests, things like that, you've worked hard for those things, and you want to be able to decide what happens with those when you're no longer around. It also can eliminate some additional stress. So a lot of people say, I just want my spouse to decide that. I just want my brother to decide that. That's totally fine if that is what makes sense for you. For me, I think my spouse would be hesitant to make some of the decisions. You know, especially if you're talking about incapacitation. You know, sometimes maybe you don't want to leave that decision up to your spouse. Maybe you don't want to put that pressure on them to decide what happens if you are, you know, in a permanent vegetative state. So in situations like that, it actually can take a lot of the stress off of your loved ones who are still here whenever you've passed. Again, it can limit family conflict. If you do have family members who have a strained relationship, then, you know, this can sort of add to that sometimes. And then I've also seen, you know, siblings who get along perfectly fine, and then their parents pass, and, you know, everybody wants the same thing, and then that creates some conflict there as well. It also gives your beneficiaries immediate access to your assets after your death. So sometimes that's not a huge concern. If you have adult children, maybe that's not a huge concern. Where having immediate access to your assets is a big concern is either if your spouse is still around and they are aging and, you know, either incapacitated or nearing incapacitation, or if you have young children and you want your guardian to be able to, you know, pay for their expenses and things like that right after your passing. So if you don't have certain measures in place, then sometimes your assets can be held up. The courts won't really know what to do with them yet, so they can't sign off on anything. And it makes it a little more difficult for people to actually have access to those assets to be able to use them. Added bonus, this is actually something that was an added bonus for me. And so I started, you know, sending people an inventory list. It also lets you take inventory of your assets. Not only your assets as in, you know, your bank accounts, your house, your car, things like that, which we generally think of, but, you know, you think about all of the online accounts that you have. You know, where do you have pictures stored? Where do you have, you know, things that you want to keep track of online stored? All right, what happens if you don't have a plan? We sort of went over some of this tangentially, but the judge gets a big say. So if you don't have a plan, the judge is ultimately the one who gets to sign off on who gets your assets, and also who gets your children. So this is a bigger concern for people with young children or minors, but the judge gets to decide if something happens to, you know, if you have a spouse, if something happens to you and your spouse together, or, you know, if there's no one who would sort of fall in line as the next legal guardian, the judge gets to decide that, and that's not really and that's not desirable for most people. Most people want to be able to determine who gets to raise their kids if they're not around. You also get to choose who you don't want in charge. So, you know, if you have siblings you may have a sibling that's great with handling decisions under pressure, or handling money, or, you know, being able to follow the rules and make hard decisions. And then you may have a sibling that's not great with that. So you want to be able to decide who gets to make those decisions. Also, it comes down to state law. If you don't have, let's go back. If you don't have an estate plan in place, it comes down to state law. So depending on whether you're married, whether you have children, things like that, it will be split however the state law of intestacy, which just means you don't have a will, however that specifies. So this, again, is a concern for people with minor children. It also can give your dependents money before they're really ready or responsible enough to handle the value of assets that they would get. There are some negative tax consequences depending on whether or not you have an appropriate beneficiary for life insurance policies and things like that, and depending on the value of your assets and what you have that would go through the probate process. And then loss of privacy is the last one. With a probate proceeding, everything is publicly filed, so anybody could potentially see what is in your estate. What can an estate plan include? Okay, so these are the documents we're going to talk about. So like I said earlier, most people think of this one right here, a will. Most people think of a will as your major estate planning document. And it really is the cornerstone of any estate plan. Anybody who comes to me saying, I need an estate plan, that's what they're talking about. I think everybody needs a will. Everything else is a benefit, but a will really is kind of the basic. A revocable living trust, we're going to get into what these things are a little bit later in the presentation. An irrevocable trust, irrevocable is just what it sounds like. It can't be revoked. It actually can in some situations, but it's really tough. So there are only a few situations where I actually recommend an irrevocable trust. You also want to go over your beneficiary designation. So that's like life insurance policies, any payable on death or transfer on death beneficiaries for bank accounts, things like that. Personal property memorandum is something that I include in all of my estate plans. I think most estate planning attorneys do actually. It basically allows you to choose who gets certain items. So for my parents, I always use my family as an example. My parents, we have a few items from my great-grandparents, who my sister and I were both very close with. So my mom has already decided, who's going to get what out of the items from my great-grandparents. And so what she did was put them on this personal property memorandum. And then, if something were to happen and say I were to predecease my parents, then that specific item would go to my sister. So you can not only say who you want to get certain items, but what you want to happen if that person isn't available to take. Retitling of assets. So you can retitle your house in the name of your trust. You can retitle a car in the name of a trust, which I generally don't recommend unless it's a high value or a sentimental value. And then incapacity planning. Incapacity planning, sometimes people get confused, like if I have a will, do I need a power of attorney? Or if I have a power of attorney, do I need a will? But they have two completely different functions. So a will only is applicable if you have already passed. So if you are incapacitated, say you were in a car accident and you're in a coma, say you have dementia or Alzheimer's, something like that, your will doesn't apply because you're still alive. So that is when your power of attorney would kick in. So your durable power of attorney is who handles your finances and also who is your personal guardian. So if you needed somebody to be responsible for you physically, you would be able to designate that person in your durable power of attorney, as well as indicating who you would want to handle your finances. Your medical power of attorney is just what it sounds like. It's who gets to make your medical decisions. A HIPAA release and the medical power of attorney, I usually do in one document. They can also be separate. But sometimes if you have a medical power of attorney, the hospital or the medical provider won't necessarily just go ahead and hand over your records, even if the person has your medical power of attorney and is able to make the medical decisions for you. So you have to sort of spell it out in this HIPAA release and say, this person has my medical power of attorney, and in addition to that, I also want them to be able to receive my records under HIPAA. Living will, this is sometimes called an advanced medical directive. It basically says what you want to happen if you are in a permanent vegetative state. You can say that you don't want to be kept alive using artificial means. You can say that you want to be kept alive for 30 days or 60 days. For women, you also want to specify what happens if you are in a permanent vegetative state or in a terminal condition and you're pregnant. So you would want to specify, whether you would want to be kept alive using artificial means until the baby was viable, or if you would not want to utilize that. All right, the documents. So now we're going to get into a little bit more specific information about each document. So the will, like I said, is the basic document for an estate plan. So a will and a revocable living trust, you'll see when we get there, they overlap a lot. There's a lot of the same information in both of them. A revocable living trust is just a lot more specific. So we'll go through the will first. You get to decide who gets your assets. So you can say, like for me, I have everything going to my husband, and then, if he predeceases me, then everything gets split evenly between my kids. You can also have what's called a custodial account or a testamentary trust that we'll talk about in a minute to handle distribution of assets for minor children. You also get to indicate what you want to happen with your debts, taxes, and expenses after death. So some debts are wiped out on the filing of a probate case. Those that aren't, you would be able to determine or to state rather in your will whether you want the debts, taxes, and expenses to be allocated sort of pro rata to each of your beneficiaries, or whether you want all the debts, taxes, and expenses to be paid first, and then the remainder to be split up. The latter is the more typical choice. The executor is who handles the distribution of your assets. So that's the person who reads the will and says, okay, this is what they wanted, and actually, hands out the assets. Maybe not physically hands out stacks of cash, but, goes ahead and makes those distributions. Guardians for minors. So it should be guardians for minors or incapacitated adults. So if you have minor children, or even if you have adult children who are incapacitated, who you still care for and are responsible for, then this is where you would state who you want the guardian to be. So I generally recommend listing a couple of backups for both the executor and the guardian. That way, if the person, especially if you're making these documents either as a young adult, or if you're making them when you're older and the people that you have designated as your executor or as your guardian are a little bit older, you want to make sure that you have backups for those people. Beneficiaries. Beneficiaries are just the people that you're leaving stuff to. So this lists out who your beneficiaries are and, whether they get certain items, certain amounts, or a percentage of the overall value of your estate. A testamentary trust. So that's what I was talking about just a moment ago. You can either call it a testamentary trust or a custodial account. So basically what it does is it says, hey, I don't want to make a whole separate trust, but I also don't want my minor children to get the assets that I'm leaving them at 18. So 18 is the default age. So if you don't have a will, or if you have a will but you don't include a testamentary trust or have a revocable living trust, any minors that you have designated as beneficiaries, like children, grandchildren, would be able to take the assets that you leave them at age 18. I was a pretty responsible teenager, and I definitely should not have been given a stack of cash at 18. Now, granted, it's not a physical stack of cash, but that's my analogy. So I think that Most people who want to designate a minor as a beneficiary would benefit from at least a testamentary trust, so that you can indicate when you want them to get those assets. We'll go back for just a second. So with this testamentary trust, what you can also do is sort of stair step it. So you can say, I want them to get 10% at 18, 10% at 22, and then, half the remaining balance at 25 and everything else at 28. So it allows you to sort of stair step it a little bit. A revocable living trust. So I got a lot of screens on this one, so bear with me. This is a very long document that most people get a little overwhelmed reading because it has a ton of functions. So what does a revocable living trust do? This is where you indicate who your trustee is. The trustee is sort of like an executor. So the executor is the person with your will who distributes your assets. So that's sort of what a trustee functions as here. So if you have a joint trust with your spouse, like I have with my husband, then you would both be trustees together. And generally speaking, spouses set it up so that when the first of you passes, the second of you is the trustee on their own. So then after that, you would choose someone. So you can choose a sibling, you can choose a friend. If you don't have somebody who you're confident in, who you're confident would be able to handle, utilizing the funds for your beneficiaries, or if you don't have somebody that you're confident would be able to remain level-headed and engage in whatever level of contact the person that's your beneficiary needs, then you can also choose a financial institution. So tons of banks and other financial institutions have trust administration departments. So that would be, like a Merrill Lynch, a Bank of America, all these places have a trust administration department. So if you have an account somewhere already, what I a lot of times recommend to clients is ask. Just go ahead and reach out to your contact at your bank and ask them if they have a trust administration department. Ask for some information on it. Talk to the people in the trust administration department and, ask them if they have fees, what their fees look like, what size estate you need to have be able to have them do your trust administration. It also helps, sort of going back to, what we said about death not bringing out the best in people sometimes. It also helps avoid family conflicts. So you can say, this is who's handling it, and there's no question about it. So there's really nobody to get upset about anything, or I guess they can get upset about it, but there's really nothing they can do. Asset management. So this allows you to manage your assets during life and after death. So for my personal trust, or for my joint trust with my husband, we have all of our assets payable on death to our trust. We also have some assets like our house that are already in the trust. So it allows you to sort of manage things. It doesn't change anything with the ownership of the home. It doesn't change anything with the ownership of the bank accounts if you did want to go ahead and transfer full ownership of the bank account. And I tell people all the time, it's hard to sort of understand what I'm saying. Sometimes I'm telling you, these things are in the trust. So the trust, think of it, instead of thinking of it like a box that you can just put something in, think of it more like the cloud. Okay, we all know our stuff is in the cloud. Like this PowerPoint presentation I'm using right now, it's in the cloud, right? But we can't touch it. We can't put it in the cloud. We just know it's there. So that's sort of what a trust is, or how a trust functions. So it's an entity in and of itself that your things belong in, but it's not a physical box that you can literally put stuff in. A trust offers you tons of flexibility. Now, this is really attractive to some people And it's really scary to other people because it offers so much flexibility that the options are basically endless. Any attorney that you have help you out with the trust will be able to give you really good guidance as far as, what your personal life situation is and what things you might want to think about building into your trust that aren't just run-of-the-mill things. So for me, with my young kids, I have mine fully utilizing the annual deductions for a 529 account for both of my kids. My husband and I also put in hours that, whenever they open up a Roth, the trust should be fully, contributing to the full extent that it can to their Roth every year until a certain age. So there's tons of stuff you can do. And like I said, any attorney that you contact about building out your estate plan should be able to give you pretty good guidance on ways you can customize that to your personal family situation. Avoid probate. So it's not such a big deal for estate taxes because the estate tax minimum is fairly high right now. It's more of an issue. Sorry about that. That's usually when I start wrapping dinner time up with my kids to make them get in the bath. So it's more about making sure that things are quick and expedient. So if your assets go through probate, like we talked about, I think a few slides back, maybe close to the beginning, anything that goes through probate, the court has to review. The court has to review it. They have to sign off on it. There have to be hearings. It also, depending on the backlog of the court, it can be kind of slow. That doesn't necessarily mean that it will be. It could take 3 months, which is pretty fast, or it could take a year. So it just sort of depends on what the court's docket looks like. It also protects your beneficiaries. So this is actually something that a lot of people have been interested in lately. So a revocable living trust offers you zero credit protection. Everything in your revocable living trust is considered to be a personal asset as far as creditors go, but it does offer creditor protection for your beneficiaries. So again, using myself as an example. So if my son decides to get married, and then he and his spouse decide things aren't working out and they want to get a divorce, then if his ex-spouse decides that they want to try to take some of what is in, the trust, some of the assets that we left to my son, they can't. It's not available to satisfy a debt, and it's not available in a divorce proceeding. That's attractive to some people, especially those with significantly larger estates, because you've worked hard for the money, you've worked hard for the assets that you're leaving your kids, and you don't want that to be available to someone else, a creditor or a potential ex-spouse. Again, I told you we're going to have a few slides here. What does it not do? It doesn't give you any asset protection as the creator. It doesn't protect against long-term care costs. That is something that an irrevocable trust does. That is something that you want to think about if you are in a position where you expect to need long-term care services or need to qualify for federal assistance, then you need to be thinking big time about an irrevocable trust. I'm sure everyone has heard buzzwords like 5-year look back. So you really want to be thinking about that irrevocable trust if you're in that kind of position. It also doesn't have any effect on the creator's income taxes. It's just a schedule on your standard tax form. All right, additional information. Okay, so this first point, I call it, not actually called the straggler provision, but that's just what I call it. So what it does is it says, hey, in your will, it says, hey, I've already got this trust. I've already said all I need to say in the trust. I've laid out how I want my assets to be split up. I've indicated who I want to be the guardian of my kids, who I want to be my trustee. You lay everything out in your trust. So I don't want to do it again in my will. So what I want you to do, if I forgot anything, if I forgot to stick anything in my trust whenever I was funding it, just put it in there and let the trust handle it. So this is a huge benefit for people who forget random things, like, you forgot a one-off bank account, or you got an inheritance from your parents and you forgot to add that into the trust, or put in a payable on death beneficiary to that account. So it just says, I already have a trust. I like how that's set up. Put it over there. Must be funded. So a revocable living trust has to be funded to be valid. A lot of people think that that's a scary thing. It feels like you're taking all of your money and sticking it somewhere else. Like I said, we're talking about the cloud, though, not a box. So you still have full access to all of your assets. It doesn't change anything with your daily life. The best way to fund it, so I put something in my trust called a magic wand provision. So it says all of my tangible personal property, including furniture, including jewelry, including anything that basically you can pick up and carry with you, all of that is in my trust. So now, like for myself and my husband, all the jewelry that I have, my grandmother's engagement ring that I have, my my ring that I got from my parents for my high school graduation, that kind of stuff. So I get to decide, I get to go ahead and put that on my personal property memorandum and indicate who gets that kind of stuff, because all of my personal property is already in there. You also want to go ahead and do the deed transfers like we talked about with the house. You can either do transfer on death, where it doesn't actually belong to the trust until you pass, or you can go ahead and put it in there. I have my deed, the deed to my house is titled in my trust. Also, go ahead and get your payable on death beneficiaries listed for checking account, savings account, brokerage account. You don't really want to do it with retirement assets. The only time that I say to put a retirement asset into a trust is if you literally have no one to leave it to. Or at the very least, list your spouse as the first. If you have a spouse, go ahead and list your spouse as the first beneficiary, and then the trust as the contingent beneficiary. And then for like life insurance proceeds, generally, if you have life insurance proceeds, I recommend if you have a spouse or adult children, leave it to them first. And then the contingent, you can either list the trust or you can set it up with called an ILIT, an irrevocable life insurance trust. Irrevocable trust. Here's the ILIT that I was just talking about. So the things that I recommend irrevocable trusts for, special needs individuals. So, people who can't live on their own, who can't take care of themselves. Life insurance proceeds, called the irrevocable life insurance trust. Long-term and Medicaid planning. So an irrevocable trust is the only place that you can have funds that the government won't just take to use for your long-term care, or to, say you don't qualify for federal aid, or to exhaust before you qualify for federal aid. Otherwise, it can just get a little burdensome. It can be really difficult to just keep living your normal life. Durable power of attorney. So a durable power of attorney is really just a financial power of attorney. So this is where you decide who handles your finances if you're incapacitated. You can also choose for it to be effective immediately or on incapacity. So the way that I have mine set up, and that I generally recommend to my clients, is all of my powers of attorney, my medical power of attorney, my durable power of attorney, all that stuff is effective now for my husband. But if my husband weren't available, then it's not effective unless or until I'm incapacitated. So that way, if, on the off chance that I ever get to leave my house without my children again, if I were on a trip, if I were gone somewhere, and he needed to do something, he has the full capability to handle whatever he needs to handle. It's also, okay, so anything that isn't in your revocable living trust, if you have a revocable living trust, the person with your durable power of attorney would be managing for you if you were incapacitated. So I guess maybe that's something I should have listed on my revocable living trust slide also. If you're incapacitated, you can indicate in the trust itself who manages the trust assets. So if your spouse predeceases you, you're the only one that's acting as trustee and you're incapacitated, you would list in the trust itself who you want to manage trust assets. Medical power of attorney. Like we talked about a minute ago, this is just, who makes your medical decisions. I also have this one set up, like I said, so that it's effective for my husband now, and it's not effective for anyone else until I'm incapacitated. So it also indicates who can talk to, so you can list other people. You can list, in addition to the person acting as your agent, you can list other people who you would like your medical professionals to discuss your information or your condition with. You can also choose in your medical POA, you can choose certain aspects of your care yourself. So not only do we have the separate living will that we'll talk about in a minute, you can also indicate certain aspects of your care on your own. So you can say, what do you want to be the criteria for being incapacitated? Do you want it to be 2 independent licensed physicians? Do you want a court to have to adjudicate you as incapacitated? So you sort of have a little control over that. And then it also, similar to what we talked about earlier with the advanced medical directive, it also has a pregnancy clause for women. So you can say, do you want the person with your medical power of attorney to be able to continue to make your decisions if you're pregnant? Or do you want to say, I don't want you to make decisions for me while I'm pregnant. I want to just do whatever's best for, whatever the doctors think is best to keep the baby alive, and then deal with it after that. Other medical decisions. The HIPAA authorization, which is actually down here at the bottom of this slide. This one, like I said, I usually build into my medical power of attorney. I like there to be less documents to give to the medical professional whenever you go in. Basically, anytime you go in for whether it's an emergent, a necessary, or an elective procedure, if you go in and you're going to be under anesthesia, they are supposed to ask you, I don't know if they will, but they're supposed to ask you if you have a living will or a medical power of attorney. So these are documents that you would say, why, yes, I do. And you would hand them these documents. Okay, so the living will, I think we talked about a little bit earlier, where you just say, what you want to happen if you're in a permanent vegetative state or in a terminal condition. All right, retitling assets. These are other things we need to do, other than just the documents that, I or another attorney would draft. These are things that need to be done as well. So I usually, all attorneys are different, but generally, I provide the services for transferring a deed, whether it's a transfer on death or whether it's just saying, hey, we want to go ahead and put our real property into our trust now, and you go ahead and file a deed. I go ahead and do that. I also, if you look at the bottom where it says bank accounts, I also go ahead and include form language for transfer on death and payable on death for bank accounts. I can't file that, but what I do is I give you the form language. I give you the form language and I say, look, either copy and paste it into a Word document and sign it and mail it, or copy and paste it into an email, which is generally sufficient these days. And then they'll either send you the form that they require back, or they'll go ahead and confirm that. Okay, so under real property, there's one other thing that I'm just going to briefly touch on because I've had this question a few times. Properties in an LLC. So if you have rental properties, you really have to deal with the operating agreement and the trust together. You still need to mention it in the trust. You still need to indicate who you want to get your interest in that business, in that LLC, if you have your rental properties in an LLC. But your operating agreement and your trust have to sort of mesh with each other. They have to be consistent, or you're sort of undercutting yourself, because then the courts aren't going to know what to do. And then instead of saying, oh, we've got these great documents here, we can just follow this, then there's going to be a whole problem, because the documents aren't compatible with each other. And then you're going to end up with your assets having to go through a lengthy, expensive probate process, when that's not what we want. Beneficiary designation. So we talked about this earlier also. So you want to go ahead and indicate life insurance and retirement assets. Go ahead and handle those things. Those are generally your biggest assets anyway, aside from a home. If you do have a beneficiary designation, like a life insurance or retirement asset, it allows your beneficiaries to take at 18. There are some, after the Secure Act was passed, there are some additional features of a revocable living trust where you can put in language that actually will satisfy the requirements of a retirement, of your retirement plans. So if you do decide to put your retirement plan into, decide to list your trust as a contingent beneficiary so that your kids aren't taking this stack of cash at 18, just make sure that, that you're following up with your attorney. Make sure that they're putting in that appropriate language, so that it's a see-through trust, so that it qualifies, so that your retirement plan doesn't have those negative tax consequences as if you were just paying it straight into the trust as a whole, as opposed to a specific retirement plan trust inside of your revocable living trust. Irrevocable trust for life insurance policies, we covered that already. And then the beneficiary of the life insurance plan. It can trigger immediate tax consequences if you don't have the right language in there. So like I said, just make sure that you're following up with your attorney, and make sure that you're very clear with them about, how you want to make sure that it's a specific trust for the retirement assets inside of your revocable living trust, so that you're not undercutting the whole, the benefits of paying out the retirement assets. Probate. Probate is a scary word to some people. I get people coming to me all the time saying, I don't want to go through probate. Everybody told me I don't want to go through probate. And I'm like, okay, is there a specific reason? No, I don't know what probate is. That's okay. Most people don't know what probate is. So probate is really just the process of filing a death certificate with the court, having the court sign off and saying, we know what their assets were handled, and now the case is closed. So if you have a will, all of your assets still go through probate, but if your will is really clear and your beneficiary situation is really simple, it's pretty quick and easy still. It really only depends on the backlog of the courts or the court's docket. If you have a trust, it's a little bit different. If you have a trust, like we talked about earlier, none of that stuff goes through probate. The court just says, oh, okay, I see over here that you have a trust, and oh, look, it's funded properly, and you've got everything listed in here. Maybe you forgot something over here. We'll stick that in the trust under the straggler provision of the pour over will, and then they sign off, and off you go. Also, since you have a trustee designated in a revocable living trust, your trustee can go ahead and start utilizing your assets for your beneficiaries, like children or grandchildren, just by providing your death certificate and a copy of the trust to your financial institution. So it's pretty quick. Why do you want to avoid probate? Do you want to? Yes, usually. The only time that you don't want to avoid probate is if you have some massive debts. Some debts are cut off at the probate filing, but since you have to go through probate, since a probate case has to be filed, even if all of your assets are in a trust, that usually takes care of it. The only time it wouldn't is if you had your, if you have like business expenses or business debts. If you want those to be cut off at death, then don't put the business in the trust. And then just indicate, you know, in your operating agreement or in your will who you want to take the business, and then those debts would generally be cut off, unless there were some sort of extenuating circumstances, or if there's another owner to the business that has not predeceased you. Why do you want to avoid it? Costs a lot of money. So generally, a revocable living trust avoids probate, but it's more expensive. A will is cheaper, but it's more expensive to go through the probate. So you're sort of deciding here whether you want to spend more money on the front end with a revocable living trust or in the back end with a will. Either way, you really can't go wrong getting something on paper. I never try to dissuade somebody from doing a will if that's what they really want to do. Clients get to make their own decisions, and that's totally fine as long as you get something down so the courts know what to do with your assets. Good enough for me. All right, now what? Now you make a plan. If you have a spouse or a significant other, you want to talk to them about who you would want to be your executor, your kid's guardian, who you want to have your pets, things like that. So, you know, just talk to your significant other. Do you want to talk to the person who's going to be your guardian or trustee? Talk to the person you want to be the guardian of your kids. Sure, talk to the person who's going to be trustee, especially if they're the same person. Don't talk to the backups. Don't talk, especially if they're all family members. I have 6 sister-in-laws, so we try to keep talking about who's going to get what or who we want to do what to a minimum, because that's a lot of girls. And then just find an estate planning lawyer that you're comfortable talking to. You're going to have to give them a ton of information, like we've talked about here. So you're going to want to give them information about how much, like what your estate value is, how much you have in assets. You also want to go over with them your family situation, you know, who you trust, who you don't, who you want to be the guardian, who you wouldn't. So you're going to have to give them a ton of information. So make sure that it's somebody that you're comfortable talking to. If it's not, that's not the right choice for you. There's tons of us out there. Definitely feel free to shop around and make sure that you find somebody that you feel like you have a good rapport with, so that you're comfortable talking to them about these sort of weird questions and issues. And then I usually tell people, make sure you get an attorney that's doing it on a flat fee, just because people tend to have a lot of questions. You have a lot of questions about advice. Like you need advice. Like, hey, this is my relationship with my brother versus my relationship with my sister. What do you think makes more sense? I had a couple of times when I first opened my own practice, I had a couple of times where people said, oh, well, I didn't ask because I didn't want to get a bill. That was the time when I decided I was doing everything on a flat fee. I want people to ask me the questions. I want to make sure everything is how you want it to be. Most of us are like that for estate planning. So just make sure you talk about fees up front with your attorney. And here's my contact information. So if you have any questions, ask. Ask me, you know, hey, what was that thing you said about durable power of attorney? Hey, what do you think about, you know, having the same person as the guardian, the executor, and the trustee? I like to answer questions. I like to talk about estate planning, maybe much to my husband's chagrin, but so don't ever feel bad reaching out and asking, because I'm happy to answer any questions I can.
Melanie, thank you so much. That's really useful information, and we do have
so welcome.
We do have a number of questions.
Great.
So once an estate is planned, does it move with me anywhere in the United States?
Yes. So here, I'll go ahead and let you look at my face again. So in the U.S., no matter where you go, everything, unless you move to Puerto Rico or other U.S. territories, then there could be a potential issue because they have sort of different rules as to what needs to be in a trust or in a will. But as long as you're in either the 50 states or DC, then you wouldn't have to have it redone just because you moved.
Okay, thank you. If I leave my house to my adult children, will they have to pay any taxes?
So there may be some taxes that have to be paid, or some transfer taxes, but if they have to be paid, they are generally nominal if you run it through your estate or if you run it through your revocable living trust. And if you do leave it to them and run it through the trust, then the trust would pay for the fees, unless you specifically wanted one of the kids to pay for the fees.
Okay. I have a child who is a minor today. Once the child turns 18, does that require a modification to the estate?
No. So I actually did my whole estate plan before I even had my daughter. And I haven't changed it. The only thing I've done is update my personal property memorandum to indicate what she gets, like what specific items, like jewelry and stuff, she gets versus my son.
Okay. We are very late to the game of doing a will, and my children are 14 and 17, almost 18. Can the 18-year-old be made an executor, or is there a minimum age for executor? Would you suggest an older individual?
So as long as they're 18, they're certainly welcome to be the executor. What I recommend in that situation is a co-executor. So you can have co-executors, co-agents for a power of attorney, and co-trustees. This is a great question, by the way. I should have covered this. It's an excellent question. So you can always have more than one person do these things together. So like if you had a sibling and you wanted your brother to do it with your son, with your older child, they could make those decisions together even.
During a person's life, new accounts are opened and some closed. Property is purchased and sold. How are the changes entered into the estate once it is written? Is the estate a live document that can change?
Yeah. So it's the estate plan is either, you're either talking about changing the asset inventory essentially for a will or a trust. So you can change the way that I build my documents, and most of us build our documents as estate planning attorneys. There's a schedule at the back, or a schedule or an inventory list, whatever you'd like to call it. So any physical property that's bought and sold, you can indicate on there if there's something you specifically want to list. Like I said, I include this magic wand provision. So it says all of your tangible personal property, so anything you can pick up and move, like golf clubs, jewelry, anything like that would be part of your either trust or your assets through your will, no matter when you bought them, whether they were in existence at the time of the drafting or not.
I think you covered this, but let's just ask one more time. So this gentleman created his will, his durable power of attorney, and his living will in New Jersey. He's now living in Ashburn. Does he need to update to his current location?
He doesn't need to update it. The only time I recommend updating it is if you have somebody locally now that you would want to serve as either your executor or your agent or something like that since you've moved. That's when I generally recommend changing it.
Okay. As the lawyer, what do you expect people to bring to you if they want your help putting these kind of documents together? What kind of answers should they have before they see a lawyer?
Yeah, so this is also a great question. So I have this enormous packet that I send people. So somebody comes to me and they say, I need an estate plan. Actually, what usually happens is they come to me and they just say, I need a will. And I say, okay, that sounds great. I say, what is your family situation? Do you have kids? Do you have parents that are going to rely on you? Do you have pets? Do you have nieces and nephews? Do you want to leave everything outright to your kids? Do you want them to get it in stages? I asked them a bunch of questions and they're like, oh man, I don't know. And so then what I did was I came up with this document. It's 30 pages long. And it has all these super specific questions in it. It's only 30 pages because I have it built out so that if it's a couple, the first 15 are for the, client one, and the second 15 pages are for client two. But it has a ton of questions in it that at least allow me to get started in the drafting process, or give me a place where I can say, okay, well, I see where we're headed here, and I think I get where we need to go. But then it gives me some insight so I can ask better questions. But really what I tell people to come to the table with is just tell me your family situation. Tell me if you have somebody already in mind that you would want to, be your executor, trustee, and guardian, and everything else we can work out from there.
A couple of people are asking how much they should expect to pay to have these documents done with a lawyer. Can you give us a range of what they might expect?
Sure. Yeah. So as I'm sure you can imagine, it depends on the family situation. I have done them for. I usually have a sort of a discount for couples, because it generally doesn't require a complete second set of documents. They're usually reciprocal, where everybody's wanting the same thing. You're just listing each other. But for an individual, for just a will, a power of attorney, a medical power of attorney, and an advanced medical directive, for that sort of package, it can be $500 to $750. I do everything in packages, so you're going to hear me say package a lot. I do everything in packages because I don't think it's a complete estate plan if you don't have your durable power of attorney, your medical power of attorney, and your advanced medical directive. So I stopped doing wills and trusts without them. So everything I do is one complete package. So if you do the basic will, maybe $500 to $750. If you want to do one with a testamentary trust, which is a will, but it has sort of like a stair-step distribution for minor beneficiaries, that's maybe around the $1,700 to $2,000 mark. And then if you want to do a revocable living trust, that one's sort of a little harder to gauge because it depends on, if you also want to have life insurance trust, if you want to have your retirement assets run through there. But you should generally plan for a revocable living trust to spend at least $2,800, usually north of $3,000. And then for an irrevocable trust or a special needs trust, you're looking at probably $4,500 or more.
Before I go on with the other questions, I want to reassure everybody that yes, this is being recorded and it will be on the library's YouTube page. I have about 25, 30 requests for the recording. Next question. I have
good. That means they're getting good information out of it.
They are, and we have about 100 people on right now. So I have properties overseas and have some assets here in the United States. How to write a trust and will covering all these? Can I include my parents and grandparents to be part of the will? They live overseas.
Absolutely. I did a trust for a couple maybe 4 or 5 months ago, and the parents were in South America. And actually the guardians and the trustees are all in South America also. It's no problem. Generally they're, the other countries will give full force and effect. Everything would just be filed here. Your probate estate would be filed here because it has to be filed in the county of domicile at your death. And then after that, the courts would just sign off on sending a judgment to, whatever country or, whatever court system is in the location of your other properties.
Do I need a lawyer to my will? It's very simple.
You certainly don't have to have one. The only situation where I tell people you really could do it on your own is if you are, a lot of times it's when I'm handling stuff for military people who are going to deploy, and they're like, oh, hey, I'm deploying like tomorrow, and I need a will before I leave. They're single, they don't own their home, and they want to just leave everything to their parents and let their parents deal with everything, then totally. If you have specific people that you want to leave your assets to, or if you if you have specific items that you want to go to specific people, if you are concerned about a family dynamic, you need your power of attorney, stuff like that. I generally recommend at least talking to an attorney and telling them what your situation is to see how much they would charge you. Things like LegalZoom can be good in a situation where, like I said, you're single, you have no dependents, no major assets, but generally they're not ideal.
Okay. Can you add online account passwords to a will or trust?
Yes. So generally what I do, I have something called an electronic inventory list that I send to people. I send it in a Microsoft Word format. It's got places for you to list out your account, your username, your password. It's, like I said, it's a Microsoft Word format, so it's you can update it as you want. You can also indicate on there if you have one of those password, I don't even know what they're called because I don't have one. Those like password manager things like LastPass. You can also indicate if you have one of those, and it's just a Word document with a whole bunch of blanks in it, and you just print it out and stick it in the binder. Most estate planning attorneys like myself, you'll get all your documents in like a binder. It'll have a bunch of tabs on it. I just sent one out yesterday, so I don't have one that I can hold up and show you. But everything will be tabbed, and I generally just recommend if you have filled out that inventory list, to just stick it in the back pocket or hole punch it and stick it in the back of the binder.
Okay. With bank accounts, do you do transfer on death or payable on death, even if it is a revocable trust?
Yes. So the reason you do transfer or payable on death is so that it will pay directly into the trust as soon as you pass. So revocable living trust won't have control over anything that's not in there. That's why we have this straggler provision in the pour over will. So if you indicate to your financial institution that you want all of your accounts to be paid into the trust upon your death, then it totally takes care of that.
Okay. Is an irrevocable trust ever used as a means to protect assets if you do not have long-term care insurance?
Yes, it is. You just have to be careful with it because it can be looked at as a fraudulent conveyance if you're sort of using it as a workaround. Like if you're saying, hey, I want to leave everything to my kid, but then I want my kid to use it to pay for me. So you have to be really careful. There are some pretty strict rules and regulations for drafting them, but it definitely can be used to take care of things like that for sure.
Can a trust be modified with a note by the trustee, or does it need a lawyer to be changed? I'm thinking of changing the distribution from thirds for our 3 children to fourths, with the portion to be distributed to the grown grandchildren.
Okay, so that definitely has to be done by an attorney. Actually, okay, so technically it doesn't have to be done by an attorney, but you have to follow the description in the trust of how amendments or changes have to be made. So like you can't just write or type up a note and then stick it in the binder or stick it with your documents. It has to follow the terms of the trust as far as how you have to indicate what you want your changes to be. And then at the very least, it has to be executed. The terms are, it has to be executed in the same manner as the original. So if your original was signed by 2 witnesses and notarized, then at the very least, the amendment would have to be signed by 2 witnesses and notarized also. I recommend at least, reading through the trust, seeing if you can find where it says how to do amendments or changes. And then, I mean, certainly the safest thing to do would be to contact an attorney, because the last thing you want to do is fill out a thing, say how you want it to be changed, and then it's not legally effective.
So how do you store and protect the information you collect from us? How do you protect our data?
So I collect the information. I give clients options. So you can either send it to me via secure email, and then it goes in my, it only goes on my hard drive. And then from there, the final documents go into a cloud server, but not the information I've collected from you. I also have some clients that aren't comfortable with that, and I will email them the packet. They will fill it out. They will mail it to me. I will finish their documents, and then I have a shredder right over here to my left, and I just shred the original documents that have any sensitive information on them.
Okay. If I use a trust and will software, do I need to register somewhere? And how will my family know that I have a will if I don't tell them?
They won't. Maryland has something called the Register of Wills. So I'm actually licensed in Maryland and Virginia both. Maryland has something called a Register of Wills, where you can go and file your document. I actually think it's kind of awesome. You can literally just go down there and say, hey, this is my will, or this is my trust. Can you file it for me? And then as soon as your death certificate gets filed, it automatically populates in their system. Virginia is a little bit more like, whoa, we don't want everybody to have our stuff. You keep yours, I'll keep mine, we'll all be okay. And so there's nowhere to file it. So nobody would know if you don't tell somebody. So like what I usually do, what I usually tell my clients, and I did it for my own also. So I scanned, I have my originals in a fire safe, where we have like my kids' birth certificates and our passports and stuff. I scanned it in, and then I, used my secure server, and I emailed it to my brother-in-law, who would be our trustee and guardian. And so he has an electronic copy.
I have about 6 or 7 more questions. Are you okay, Melanie?
Sure.
Okay.
Yeah,
yes.
I'm good.
If I wrote my will myself, is it considered legal?
So it is, if it's fully in your own handwriting. It can't be typed. If it's typed, it doesn't count. If it's fully in your own handwriting, or if you type it up and you have it witnessed by two, okay, so this is key in any will. It has to be disinterested witnesses. So all wills and powers of attorney have to be witnessed by two disinterested witnesses. So what disinterested means is it can't be a blood relative, it can't be a relative by marriage, it can't be anybody who would legally be entitled to something, in like a doomsday worst case scenario situation even. So like nobody that would inherit anything from you if you died without a will. So, get a neighbor, go to the bank, go to the UPS store, random strangers off the street, get anybody, but not somebody who would inherit from you if you pass without a will. So if you typed it up, it has to be signed by witnessed by two disinterested witnesses, and then notarized also. If you have fully written it out in your own handwriting and signed it and dated it, then it doesn't have to be witnessed or notarized. Although, frankly, why would you, even if you're handwriting it out, just go ahead and have it witnessed and notarized. There's no reason to chance that.
Okay. How do you know the lawyer used is knowledgeable and trustworthy? And what happens if you hire a lawyer and then they move or they stop practicing or something?
So this is why Virginia does not encourage attorneys to keep originals anymore, actually, because it has happened too many times where an attorney has moved or stopped practicing, and people go to get their documents and they have no idea where the lawyer is. So we don't keep originals anymore. I either hand deliver or I mail a physical binder with all the documents in it to my clients. How do you know if a lawyer is trustworthy? Ask people. Ask people, check Facebook reviews, check Google reviews. People like to leave reviews. They especially like to leave reviews if they're mad, if they're not happy with something. So check out the bad reviews. Some of them may just be, people who wanted a consultation and weren't able to schedule one. But check out the reviews from people who say, I hired this person and XYZ happened. But there's really no other way. There's really no other way to find out. I generally say if you can ask around, if you've got a friend or a family member who has used somebody and they were happy with, give them a call.
Okay. Is it mandatory to have 2 witnesses during notarization for amendments to my trust or during will and trust creation, as I want my trust contents to be confidential to outside my family?
Yes. So you still have to have it witnessed by 2 people. So the trust doesn't have to be witnessed by 2 people. I usually have 2 witnesses and a notary. I generally function as a notary. The witnesses don't read anything, though. The witnesses aren't there to read your stuff. They're not even entitled to look at your stuff. The only way they would get to look at the contents of the document is if you literally opened it up and said, "Ooh, look what I did." The witnesses are only there to function in this capacity. They're there to say, I'm here, I'm acknowledging that the person whose name is on this document is actually signing it, and I'm acknowledging that no one's forcing them to sign it. That's the only function of a witness. They are not there to read your documents. If they're reading your documents, something's wrong.
Is there a life insurance registry?
No.
Okay. Are the trusts like bank accounts, software, or a document?
It's a document.
Okay. Is an
It's a physical document.
Is an electronic copy of a trust legal, or does the trustee have to have the original?
An electronic copy is legal, as long as it's furnished with with the death certificate, if it's not the original grantor that's acting as the trustee, or as long as it's furnished with a driver's license as well. But an electronic copy, like I have used the electronic copy of mine, and it's totally fine.
Okay. And the last question, do you recommend only having one executor? My mother wants to have 2 of us serve together so we can make all decisions jointly. I suspect this is going to make things more difficult.
It's not a great idea. You suspect right. It's not a great idea because ultimately you will certainly have different ideas of what is appropriate and not appropriate, or what is the best idea. If she's torn, then probably the best idea is to not have either of you, and to have like my parents were concerned that there would be some contention between my siblings and myself. And they selected my uncle, and the backup to my uncle, I think, is my oldest cousin. And we were all like, thank you.
Thank you. I was going to ask you about that because another lawyer had told me you don't want your children to be your executor. I mean, that's open to opinion, but she said,
right.
You'd be surprised that the family that gets along the best can even have issues with that.
Totally.
And take the pressure off your kids. Just
absolutely.
Yeah.
They're going to be so stressed out when
Exactly.
you pass anyway. That's like the last thing they need. Like my mother and her sister and her brother get along great, but my mom was listed as the executor for my grandfather's will when he passed, and my uncle was not thrilled.
Right. Yeah.
So don't do it.
Yeah.
Pick one of your siblings, or pick best friend, or pick literally anyone else.
Right. Someone with no skin in the game, right?
Yes, exactly.
Just one more question snuck in here. Can I create my trusts? And if yes, what are the difficulties?
Can you create a trust?
My
Like on,
trusts. I think what this person is asking is if they can create their own trusts like they would their
ooh,
will. Is that what you mean?
no,
No. Yeah.
no. I mean, technically you could, but there's so much like red tape. There's so many formalities that you have to meet um, for the court to be able to say, yes, this is a legally binding document. This is a properly formed trust. That it's just not worth it. I mean, like I said, a trust it's not cheap. You can, generally most of my clients end up spending about 3,000 on a revocable living trust plan. And that's a joint revocable trust for the spouses, two pour over wills, one for each, two durable powers of attorney, two medical powers of attorney, and two advanced medical directives. And that's not an insignificant amount of money, but you're also saving so much on the back end because you're not having to, your estate isn't having to go through the headache of, the court having to figure out what to do with your assets. So it's a pretty quick process on the back end, which we saw with, like I said, my grandfather passed a few years ago, and he and my grandmother have a trust and a will, which I didn't do because I'm not licensed in Texas, and that's where they are. But they're, my mom had very little that she actually had to deal with the courts for because everything was already set up and she already had access to everything through the trust.
Yeah. So I lied. I have two more questions, but they're really
That's
good
all right.
but I promise this is it. Is there a standard
That's all right.
compensation we should put in the trust for an executor? That's a very good question.
That is a good question. No, there's not a standard compensation. You just want to indicate whether or not they can be compensated. Generally, if you have a relative, if you do pick, a sibling, if you, on the off chance that you pick a child, if you pick somebody that's also a beneficiary, you want to not give them compensation because it can create some further family drama. If you're picking a friend or a sibling, then that's fine. But if you have one of your children listed, I wouldn't do it. I just would list in there whether or not, what I usually do is I list whether or not they can be compensated. And then you let the court decide. The court generally will sign off and say, this is reasonable. You put in there that they can be paid out of the estate a reasonable amount. And then the court will say, okay, this is what we usually do. Because otherwise it's too hard. Like we can't put an amount in now, and then who knows if that changes in 20 years.
Right, right. So last question. The library does a program called the Five Wishes document, and it's pretty specific about what you want your end of life to look like. So is there someone you don't want to be in the room with you? Is there someone you definitely want to be in the room with you? Do you want music? Do you want to live if you have this condition? Do you want to not live if you have that condition? Do all those things go into one of the legal documents too? Or does it get that specific?
So the advanced medical directive will cover whether or not you want to live if you have certain conditions.
Right.
And it covers, sort of whether or not you want to be given artificial life-sustaining measures, or whether you just want comfort care, and, just be kept so that you're not in pain. I also provide something which I only started providing whenever I did my own, because I realized it was something that I, as my own client, I guess, wanted. I provide something called a medical memorandum. So it says, this is when I made my medical POA. This is when I made my estate plan. I'm providing the following guidance regarding my medical care. I also have an end of life care memorandum or a disposition of remains memorandum. I provide these because I wanted it. I wanted to say, I wanted to be able to change later on what sort of medical care I wanted if I felt like it. I wanted to be able to change what I wanted my end of life ceremony to look like, or where I wanted to be buried or cremated. Because I don't have a plan for that right now. So I came up with these memorandums that fit into sort of an exception, so they don't have to be notarized. It's something that is mentioned in the will or in the POA, and so since it's specifically named in there, it's just sort of a document that goes with the will or with the medical power of attorney.
Smart. Okay. I promised that was the last question, and it is.
Yeah.
Thank you so much. I really can't thank you enough for this information.
Yeah,
It's
sure.
useful and helpful. Can you put up your contact screen again? Because I know some
Sure.
people have some follow-up questions for you.
All right, you see it?
Mm-hmm. And then
Okay, perfect.
I'm sorry, I'm in the dark here too. To everybody asking about a PowerPoint being available. No, there won't be a PowerPoint available, but you can look at the recording, and that will be on the library's, Loudoun County Public Library's YouTube page in a few days by the beginning of next week. Thank you all for joining us. Thank you again, Melanie.
Thank you so much for having me.
You're welcome.